It's a great pleasure to be here. This is a very exciting moment. I really want to thank Prava Katishwaran and Pierre Bonson for the imagination and the creativity of putting together this workshop. I've been part of early career workshops of the Law and Society Association for a few years, and I know that these are really transformative and exciting moments. But the idea of doing it for 2 weeks and bringing in this professional training as well as the intellectual piece is, I think, a really wonderful idea, and I'm so glad that the King's College Law School has done this, and I hope you will be a model for other fields as well. So it's really fun to open this inaugural process. And I think it's important to see that we are beginning to consider a core question here. That's a very challenging question, and that is, how does transnational law actually work? It is not an easy issue. Is it like domestic law, or is it a new species of law? This is a critically important question, given our increasingly interconnected world, where we have technically sovereign nations linked by multilateral treaties, international organizations, UN governance systems, and of course, myriad social, economic, and political ties. How can law possibly function in this very complicated world? There are inconsistencies and contradictions, there are jurisdictional uncertainties, conflicts of laws, and a situation of global legal pluralism that some see as fragmented and chaotic, and I think this is a theme that you're going to see the rest of this week. These systems clearly don't mesh neatly, nor is it easy to make them fit. They have different logics, cultural assumptions, practices, and political frameworks. And yet, somehow we go on, we muddle through, and how exactly that happens is really the challenge that we all face trying to understand what transnational law is. And what I want to persuade you is that there are socio-legal and even anthropological techniques and methods that may help us understand this. I should point out that this legally interconnected world that we now live in is not actually a new thing. There were, in the 19th and even 18th century, lots of legal interconnections, but these were organized under the rubric of colonialism, in which the world was interconnected through networks of colonial control and the replication of colonial legal orders all around the world. So there were, of course, British courts in Africa and India, there were French courts in Indochina, American courts in Hawaii, to sort of bring my own country's colonial past. But our interconnection now is of a somewhat different order. I think that understanding this plural system poses a challenge to legal analysis. Legal analysis, as I understand it, being a non-lawyer, but teaching a lot of law students, legal analysis focuses on developing clear categories, finding underlying principles in this messy world by which situations can be compared, and somehow arriving at logical conclusions based on these principles. Ideally, the system should be integrated and predictable. But this approach doesn't really work very well with the systems built up from myriad local political, social, and cultural practices that have been developed to solve particular problems and organized to work around recalcitrant countries and weak enforcement systems and respond to various different cultural practices. So the difficulty that understanding this transnational multiplicity poses for the legal analysis came to me vividly when I was teaching a class of law students in a course I called Gender, Culture, and Human Rights at NYU School of Law. I began by asking about the fundamental categories of the course. We started off with, what is gender? Well, is gender a binary? Not entirely. It's actually a continuum. It's performative. It's fluid. Well, this was a little disturbing to the students. Then we said, what is culture? Well, culture is not actually this homogeneous integrated whole, but it's porous, it changes, it's contested. Well, this was difficult also. Then we turned to human rights. Well, human rights are law, but what kind of law? Well, actually, human rights are claims, but these claims are not necessarily enforced, nor even necessarily widely recognized. Compliance depends on making claims, but also social movement mobilization, civil society activism, the support of powerful governments. Claims may not be recognized. Compliance is hardly guaranteed. It depends on a variety of economic, political, and social pressures, both domestic and international. The socio-cultural analysis of human rights I offered the class showed that this is an uncertain process based on slippery categories and weak legal enforcement. Well, after a couple of weeks, I had a revolt on my hands. There were some of the students described my approach as theoretical suicide. I was intrigued by that. Others said I was undermining human rights, and if the goal of law is making categories clear and principles coherent, I was clearly doing the opposite. In the end, however, most of them came around. Actually, one even went into socio-legal studies, and they said that they actually now understood better how international human rights actually works in practice, that it has to be understood through social processes, political pressures, and ambiguous social identities. But it isn't an easy thing to make, and it is quite different from other modes of thinking. So this is the question that I have been dealing with myself for the last couple of decades, which is, how can we understand how the system works? I've been curious about what is really going on, how this law is formed and used, how it has an effect. It is, of course, a form of legal pluralism, stacked on top of domestic law in a wide variety of ways. And in some ways, it's parallel to the situation produced by colonialism. And actually, my interest in human rights law began from previous research on law and colonialism, in which I looked at the way American law was imposed in Hawaii and appropriated in a complicated pattern during the 19th century. And I saw human rights as yet another version of legal pluralism. My argument is that in order to understand the way transnational works in practice, we need to bring a socio-cultural perspective to the problem. We have to see transnational law as a social process. It's like domestic law, but since it's applied across national boundaries, there are ways in which it's fundamentally different. Understanding how transnational law works in practice requires a rethinking of law itself, the way it operates, its inconsistencies and limitations, the way it gets implemented, the role of normative versus coercive pressures, and finally, its plurality. So I advocate at least two approaches to studying transnational law. My approach comes from the perspectives, first, of law and society scholarship, and second, legal anthropology. Now, I've been engaged in the field of law and society for a few decades, who's counting, and in the past, this scholarship was resolutely focused on domestic, that is to say, national law, largely on the US and Europe. Until the 1990s, international law or transnational law was really not examined at all. But recently, there has been a real fluorescence and explosion of interest and a concern in applying socio-legal theory to transnational law. This is not the same approach as comparative law, but instead an analysis that looks at the interactions among countries and the circulation of ideas, laws, movements, and money. It means seeing law as embedded in social, cultural, and political structures and asking the core law and society question of the relationship between law on the books and law in action. But of course, it's much more difficult in the transnational arena. The second perspective I bring to understanding transnational law as a social process is legal anthropology. Now, legal anthropology tends to focus on small social spaces, looking for systems of meaning and practice in the way they are shaped by their larger contexts. How then could you possibly use this to understand transnational law? Well, my argument is that from this perspective, one can study transnational law in the office of a human rights organization in Bangkok, at a Human Rights Council meeting in Geneva, at the meeting of the International Commission for the Conservation of Atlantic Tuna in Madrid. I have Jen Teleska, a graduate student of mine, has studied this. Or you can look at, this is where countries establish their quotas for tuna harvesting. Or you can look at this at the Committee for World Food Security in Rome, where a multi-stakeholder body, including states and civil society, works between NGOs, governments, and private interests to negotiate how we deal with the World Food Policy Program. And my student, Matt Canfield, will join you soon, and he's been doing this research, so you may hear more about it. Each of these sites provides a glimpse into the way this very diverse and complicated system works. And it is this system that we need to understand in a socio and cultural sense, not just a legal one. Transnational law is, of course, also deeply plural. The idea of legal pluralism originally came from anthropological research on the study of courts and disputing mechanisms in colonized and post-colonial societies. Under these conditions, there were obviously plural legal systems, one indigenous, another colonial, and actually in practice often a third called customary, which was some kind of a merger of the other two. Transnational law adds one more layer to this multiplicity of forms of ordering. Now, as we turn to understanding transnational law, one of the challenges is the issue of sovereignty and inequality. In the international system, every country is equal, theoretically. So there are 193 members of the United Nations. Every country has one vote. That means Tuvalu, an island in the Pacific with 10,000 people, has one vote, as does China with 1.4 billion. Can transnational law control both countries equally? If each one violates human rights treaties that it has ratified, will the response from the so-called international community be the same? Clearly, powerful countries have a lot more power to dictate the way things happen, and they are also far less vulnerable to many forms of transnational law than small and economically weak ones. And yet, on the other hand, they also manage to carry out trade negotiations and reciprocal trade treaties that are quite effective and do bind them. So it's a complicated world, but the relative inequality of power is a fundamental piece of this problem. We can see the impact of this inequality in stark terms if we look at the condition of international criminal courts at this moment in time. Now, one of the great promises of transnational law is that relations between countries can be managed through law instead of through violence. This is the early and ongoing promise. The development of international criminal tribunals to hold leaders accountable for their acts of crimes against humanity and genocide clearly represents part of that vision. And yet, this model is foundering on the problem of sovereignty and inequality. Some countries have refused to participate in the International Criminal Court, typically large and powerful countries, and some countries have chosen to ignore it because in the name of sovereignty, it doesn't have its own police power or military force. So, if powerful countries refuse to support the International Criminal Court or refuse to ratify the treaty, does that undermine its effectiveness? Will it ultimately fail? And clearly there are risks here. Even in the last few weeks, you may have noticed that the indicted head of state, Omar al-Bashir of Sudan, who was in South Africa for a conference, was allowed to leave even though South Africa is a signatory to the ICC and had an obligation to keep Bashir there under the indictment he faced. And last week, India invited Bashir to an India-Africa summit next October, despite his indictment. And of course, Prime Minister Modi pointed out that India has not ratified the Rome Statute and is not a signatory to the ICC, so it's not bound by its terms. So clearly there are a lot of politics as well as law at play in this case, and not all players are equal. So in this talk, I want to focus on one small slice of the transnational legal world, that of human rights. Human rights are enormously important in their aspiration to establish a universal normative legal order for the benefit of all humans, regardless of their nationality. I mean, this is a really amazing idea. I present this to my students as an amazing idea, and they sit there looking blankly and unenthusiastic at me, which I find kind of surprising. But it is really, in the normative terms, quite a dramatic development. On the other hand, the system is far from uncontested, as you know. It is clearly not widely successful. And so it presents an interesting place for us to examine how transnational law works in practice, and what its strengths and problems are. So I'm going to look at two quick examples in this lecture. First, I'm going to look at how a human right is created and becomes embedded in human rights law. And secondly, I'm going to look at how social processes of quantification create and solidify categories of social phenomenon that become regulated, such as human rights violations, and how the magic of numbers facilitates the construction of these legal categories. So my first example is to say that human rights are not found but created as a result of social movements. And I show this through the example of how violence against women became recognized as a human rights violation. It was the result of a long process of mobilizing a global social movement and finding a way to define the problem as a human rights one. So to give you a little history, in the 1970s and 1980s, there were mobilizations of national women's movements in countries around the world, began to focus first on rape, then subsequently on domestic violence. There had been a concern, the previous concern about domestic violence had been fairly limited. It was often viewed as a lifestyle problem or a product of drinking, so there were temperance campaigns against the drunken brute. But under the influence of 1970s feminism, it became a problem not just for poor women, but for all women. In trying to understand women's subordination, there was a turn to seeing violence as a fundamental piece of subordination that all women experienced, and therefore it became universalized as a problem that all women had to worry about. But this was a relatively new problem. The Women's Convention, the Convention on the Elimination of All Forms of Discrimination Against Women, which doesn't trip off the tongue, but anyway, called CEDAW, did not mention violence against women. It was not enough of an issue by 1979 when it was finalized to merit mention. But as the 1970s and 80s feminism redefined this, they built shelters, they passed laws, and they began to generate a global movement in Latin America, Europe, North America, South Asia, and China. As the movement developed, some of the leaders decided to see if they couldn't redefine this problem as a human rights issue. Now, that is in some ways an easy call. Violence against women, rape involve injuries to the body. The human rights system is very fundamentally engaged in protecting the integrity of the body, so it's a logical thing. In fact, some feminists argued that domestic violence should be defined as torture, and that it fits nicely into the concern that the problem that the human rights system has with torture. But there's a difficulty. The human rights system focuses on states. It tries to get states to protect the rights of its residents and not to violate them, and also to do things that improve the rights of its residents. But domestic violence and rape aren't carried out by states. They're carried out by non-state actors. And there was a move towards the late 80s, early 90s to think about how human rights could begin to incorporate non-state actors. So some of the leaders of this movement came up with a clever idea of arguing that if states refuse to prosecute violence that takes place within families or violence with female victims less assiduously than they prosecute cases where a man hits a man or a case that takes place outside of the family, that state is responsible for discrimination on the basis of gender. And so here you've turned the action of a non-state actor into a case of state gender discrimination, and it becomes a mainstream human rights problem. And I think this is yet another example of the kind of creativity by which this problem gets defined as something that merits the attention of the human rights system. So activists from many countries then began to mobilize this idea and bring it into the institutional apparatus and mechanism of the UN and the human rights system. And I have a list of events from the CEDAW adding a general recommendation on violence against women to the UN Conference on Human Rights in 1993, which concluded that in its final declaration, human rights, violence against women, that human rights of women were an inalienable, integral, and indivisible part of human rights. They also called for the appointment of a special rapporteur on violence against women, which happened in 1994 by the then Commission on Human Rights. And also in the early 90s, the UN Commission on the Status of Women developed a declaration on the elimination of violence against women, unanimously adopted by the General Assembly in 1994. And the Beijing Conference in 1995 again included violence against women as a human right, arguing in its platform for action, violence against women both violates and impairs or nullifies the enjoyment by women of their human rights and fundamental freedoms. The long-standing failure to protect and promote those rights and freedoms in the case of violence against women is a matter of concern to all states and should be addressed. So you can begin to see how this idea is being incorporated into a variety of UN institutions. In 2003, Amnesty International's U.S. division initiated a major global campaign against violence against women. And in 2003, the General Assembly asked the Secretary General to do a special report on violence against women, which was presented to the General Assembly in 2006. So this is the first time the General Assembly actually discussed this issue, but you can see it's been a long incremental process. The report asserts that violence against women is a pressing human rights issue and highlights the need for governments to respond more effectively and to gather more data. So we can see that defining violence against women as a human rights violation took time. It began from national social movements, moved into human rights institutions through policy statements, then declarations, and then becoming part of the major convention on the rights of women. Clearly, there's still fragmentation and overlap. A woman who is experiencing violence could technically appeal her problem to at least 5 human rights conventions. She could clearly go to CEDAW, or the Convention Against Torture Committee, or the ICCPR, which actually protects bodily integrity. If she's under 18, she could appeal to the Convention on the Rights of the Child. If there's a racial dimension, you could go to the Convention on Racial Discrimination, or if a person has a disability, she could go to the committee that monitors the Convention on Disability, Persons with Disability Rights. So there is overlap and complexity that is inherent in this process. But my point is that this is a human right that is made, it is not found. Other human rights have followed a similar path. Disability rights, you could see the same pattern. The anti-trafficking movement has also engaged in a global movement that is now coalesced into various kinds of transnational laws. And Indigenous rights is a similar process. It has moved from 1980s discussions by Indigenous peoples at the UN to ultimately a declaration on the rights of Indigenous peoples that was passed by the General Assembly. However, the Indigenous rights movement has been much less successful than the violence against women movement and even the disability rights, which produced a convention, and the anti-trafficking movement, which also has produced laws, but in this case not about human rights, but about organized crime. So it's worth thinking about why the Indigenous rights movement has had less success. This is actually a politically less powerful organization. There has been a special rapporteur created for Indigenous peoples. There is a UN Permanent Forum on Indigenous issues. There is a sense of Indigenous identity, and yet the movement to establish Indigenous peoples' rights has been fought by some rather powerful actors. When the Declaration on the Rights of Indigenous Persons was passed in the General Assembly in 2007, there were 4 countries who abstained: the US, Canada, Australia, and New Zealand. These are not actually the countries you want to have as your enemies if you're trying to promote your human rights. But what's at stake were Indigenous peoples' claims to resources and control over their resources, and clearly these countries found this threatening. They have subsequently sort of gone along with this, but somewhat reluctantly, and we're still talking about a declaration. This is not a convention. This has not been the most successful movement. So the creation of a human right is a matter of mobilization, social movement activism, and political power, and it can be stalled or it can be promoted. So we have to look at the various power dynamics and understanding how this happens. But I'm suggesting that we see human rights as a product of social movements and transformation, not as something that is natural. They are made, not found. Does this undermine their legitimacy and authority? I think there are some who would argue that they have to be seen as natural. I think the legitimacy comes not from natural law, but from these very social movements, which were originally European, there's no doubt about that, but these days are increasingly global. That doesn't mean all players are equally powerful by any means, but that we are at least having a global conversation about how human rights get established. So, that's my first example. I'm going to do it for time. The second thing I want to say a little bit more briefly is to talk about the contribution that quantification makes to establishing transnational law. And this is the research that I've been doing for the past few years, which in a way seems like a shift. I got interested in this because the Office of the High Commissioner of Human Rights decided that in order to facilitate compliance with human rights, they would develop a series of indicators of human rights compliance. And those of you who have watched things like the Millennium Development Goals and now the fights over the Sustainable Development Goals recognize that increasingly quantification and indicators are the mode by which we are engaging in governance. This is not new. If we look at the history of the development of the modern nation state in the 19th century, the development of state governance came right along with the need to gather data on populations, to get statistics on birth, death, health, capacities, education, and so on. And we have simply expanded this knowledge base in enormous ways, and they have now become transnational. So transnational governance needs transnational statistics. And what we find is that the demand for numbers is actually in part a demand to define a problem. Many of the problems we deal with these days are very hard to pin down. What is corruption? What is the rule of law? What is trafficking? These things are all very vague and ambiguous concepts. But if we start out to measure them, we end up having to specify them. And in the act of specification and quantification, the thing actually develops a fixed entity and being in a way that didn't have before. So to bring in a familiar analogy, we don't actually know what intelligence is, but we have a test that measures intelligence, and so we figure that's what intelligence is. It's what the IQ test measures. And we also, maybe you all are familiar with this, use grading in schools to decide whether people are good students or not. And so whether that's actually a marker of whether you succeed in life or not, or whether you're really intelligent or not, we use these measurements as a way of defining this elusive phenomenon of intelligence, and then this moves forward. And it's interesting to notice that not only do these things measure your alleged intelligence for the rest of the world, but there's a subjectivity to it. People tend to own these ideas and come to understand themselves through the way they get measured. So, how does quantification contribute to transnational law? When something becomes identified as a problem, such as poverty or human trafficking, there's always a demand for data. How big is the problem? Who is suffering? And how should it be treated? For example, as human trafficking emerged as an important issue in the late 1990s, there were endless demands for more numbers. But these numbers range wildly from a report of the U.S. State Department Trafficking in Persons in 2013 that said that there were 46,000 victims that the State Department had identified all around the world. Meanwhile, the Global Slavery Index says that there are 35.8 million modern-day slaves. Well, that's a little bit of a disparity, don't you think? Now, this is what I'm going to show you is the Global Slavery Index. Oops, where is it? Oh, I have to do something else? Where did you put it?
Just exploded.
What? I did that. Oh, okay. So this is the Global Slavery Index, which is an annual report put out by an organization called Walk Free in Australia. Oh, it's funded in Australia. It's actually the author is Kevin Bales, who was in the UK. And what this does is give you the number of slaves in every country around the world and rank them from top, the country with the most slaves, to 160, the country with the least slaves, and you can click on any country and you get their rank and the number of slaves, with an estimate, and yet there are numbers in all these countries, you see. And so what we have here is a quantification of a social problem. Even though it's very difficult to know who's trafficked, who's a slave, who's doing the counting, and we find that this is now a way of making a problem known through, I call this speculative quantification. Any of you know who's the country with the least number of slaves? Any guesses? Norway. We'll see how Norway's doing. Norway's ranked 163. It has 700 slaves. Last time I looked, this is 2013. Iceland is the winner, which has 23 slaves.
I'm going to go personally.
How do we know there are 23 slaves? I mean, this seems ridiculous to me. I probably should see, how many slaves do you think you have here in the UK? 8,300. So the UK is doing pretty well, but there are 8,300 slaves here. Now, apparently there's 60,000 in the US. Okay, so this is an example of how you use quantification to build an issue, to build a category, despite the fact that what the definition of a slave is that they use is very vague. It depends on your embedded social relationships. The ability to actually count the number of slaves depends on very difficult and careful research, since it's typically illegal. These people are hidden. Are they debt bondage? Is it some other kind of traditional informal relationship? Are these maids who work in the cities for rich people? It's very complicated, and yet this is the way we use quantification to support international law and the causes as I try to figure out how to get back to mine. Do I do escape again to get back to mine?
There's no escape now.
This is the PowerPoint. Now what do I do? All right, no, I have to go forward. All right.
Okay.
Now what have I done? Now it's doing this wrong thing. Next.
Yeah.
Next. Okay.
And then, good.
All right. So here we are. I'm better writing books than I am at running PowerPoint.
Good job.
It's an age problem. Okay. So this is all to show you that quantification is now a really important way to define what it is we're governing. And that in order to govern a problem, we have to have knowledge about it. But it's very difficult to know what you count and how to count. And we have to think about who's doing the counting, who's defining the categories, and there's power underlying this. This is actually Foucauldian power knowledge nexus, because those who are educated, cosmopolitan elites tend to define the categories, to define what gets counted, and therefore construct the world that we live in, and that is the basis for governance. So let me ask you to think about one simple problem. One of the things that this Secretary General's report did in 2006 was to say, we need data on violence against women. How frequent is it really? I mean, if you have 50 people being beaten, we're not really going to worry about it, or 10 people trafficked, but if they're 35.8 million, maybe we'll care about it. If half the women in the world are beaten, we care about it. So you need the numbers in order to build the issue. So the Secretary General's report asked the United Nations Statistical Commission to come up with a survey instrument on violence against women. Now this might seem like an easy thing to do, but what exactly should one count? Should one count the number of husbands, wives who were hit by their husbands, the number of women hit by their boyfriends, the number of women raped by soldiers, the number of women who have female genital surgeries, the number of honor killings, boyfriend-girlfriend fights, verbal insults, blows, serious injuries, minor injuries, dowry murders? It's really hard to think about developing a coherent category that can be used to count across cultures, classes, countries. And of course, gathering this information is incredibly expensive, just like gathering information on the slaves is. This is being supported by, I gather, I don't know if you know about Andrew Forrest, an Australian mining magnate. whose record with indigenous peoples may not be wonderful, but anyway, maybe you know more about this. So the information is expensive and difficult. Do you interview people? How do you interview a woman about whether or not she's experienced violence when she's in her home and her family members may know? She probably doesn't want to talk about it. Maybe she considers it normal and she won't even tell you. She may just think this is the way life is. So gathering this information is very difficult, but in order to intervene and regulate, nations and organizations need to have numbers. Many issues subject to transnational law are very hard to define. Corruption, violations of human rights such as the right to food and affordable housing. What's the right to water? How much water? There's some effort to say everybody needs 50 liters of water a day, but does that make sense in a desert as well as a rainforest? How can you measure racial discrimination in countries that don't have clear categories of race, which many don't? Quantification and indicators help to establish and fix a concept such as the rule of law, corruption, or the human right to health. But they do so through specifying and making fixed things that are in practice much more ambiguous. Numbers, of course, also bring visibility to an issue by showing its size and importance, and may help in compliance. This was the goal of the Office of the Human Rights Project, of coming up with indicators for 12 human rights. In order to measure compliance, they felt it would be important to have clear measures about what constitutes compliance. But this project that started in 2005 and developed through 2008, by the time the final guidelines came out in 2012, they no longer said this was about compliance, but it was just about giving a toolkit to countries who want to monitor their own human rights. Perhaps there had been some political pushback to the compliance idea. So if a subject of transnational regulation is vague and unclear, quantification converts it into a distinct bounded issue which can be identified and counted. This is the magic of numbers. But of course, the numbers are themselves the product of cultural assumptions and political pressures. So these are my two examples of how a sociocultural analysis of transnational law might help us understand it. Now, I wanted to leave you with some questions to consider for the rest of this institute, which I don't really have answers to. One of which is, back to how does transnational law work? Can it hold countries and individuals accountable? Can it enforce law despite this problem of sovereignty and every country having the right to remain sovereign in the international arena? And there are questions about the nature of the normative order that transnational law can create. Is it successful in building some kind of transnational normative system, and does it work better if this is seen as a law rather than just a normative order? Seems to me there is a contribution that claiming something as law makes, regardless of how well it's enforced. Does transnational law produce compliance? And if so, how does it? Do indicators help? In the absence of strict enforcement, can we have compliance as the result of normative commitment? And again, I ask you to think about domestic law, where lots and lots of compliance takes place in the absence of any kind of direct enforcement. So there's a possibility here, but of course you run into the whole international relations argument versus international law. Do countries only follow their self-interest? Do they actually take law into account? And then we have a question about fragmentation. There's clearly a deep fragmentation of international law. It has multiple sites, organizations, and rules. Do these weaken its power to contribute to global and contribute to increasing global chaos and disorder? Or does the fragmentation produce more opportunities? Think of the woman who's got 6 different UN treaty bodies to apply to in her case of violence. Does it make it more possible to mobilize law for a variety of purposes? Is this openness or is this chaos? And I hope I have persuaded you that there's more to transnational law than law, that it also has to be seen as a socio-cultural and political process, one that changes over time, that depends on its context. You will have a chance to explore these ideas in the next 2 weeks and to develop a nuanced, socio-culturally sophisticated understanding of what transnational law is, how it works, and how you can contribute to the next generation of studying and understanding its processes.